saw the sign-in sheet there. If you could just sign in, and online, if you scroll down on the viewing page, you can see where you can request CLE credit. We do have our next training coming up on May 13th. It's part of our JL for Minors series on parent-child separation and the effect on guardianship cases. And if you're interested in volunteering for CDLS, we have volunteer orientation every month. And but today we're here for Alan Borlak. He is a very distinguished litigator. He's litigated almost every commercial area of law, and he's also represented clients in appeals and before the Supreme Court. You can catch him at the May 21st training on animal rights and abuse at the CBA as well, because he serves as a chair for the animal law committee there. But today he's here to talk with us about the perils of voluntarily dismissing without prejudice. So,
thank you, Tracy. It's a pleasure to be here today and to be speaking to lawyers who recognize the great privilege that has been bestowed upon you and want to give something back. And I certainly appreciate that, and I admire that, I respect that, and like I say, it's a pleasure for me to be here speaking before you. I'm going to be speaking about the perils of voluntarily dismissing without prejudice, or beware what you dream for. And some of you may be thinking, what's with this guy? All I want to do is dismiss my case. I'm not asking the judge to give me any money. I'm not asking for any relief. Just let me out of here. Why could that be a problem? Maybe it's like when you go to the bank and you just want to make a straight deposit and they say, we'd like to see your driver's license. You say, wait a minute, I just want to give you money. I mean, who's going to complain about me depositing money in somebody else's account if that's the case? Well, it's the same thing. In fact, there are perils. And in life, in litigation like life, we have to know our risks in order to be able to manage them. And there are risks here. We're going to talk about it. And by the end of this presentation, I hope that you're up to speed on the risks. You can evaluate them, you can manage them, and you can find your way through the thicket and the traps for the unwary that exist here. If we go to page 3 of the handout, we have the quotation of Section 2-109 of the Civil Practice Code of Civil Procedure. And that gives the whole statute. But if you notice, there's a few things here just to point out. In order to dismiss, you need to give notice, you need to pay costs, and your dismissal is without prejudice. And this is all going to happen, and all can happen pretty much unfettered until trial or hearing begins. At that point, it's a new game. Now the judge can fix the conditions, very much like federal court does. And so this whole presentation really talks about what you can do up to the point of trial. After that, you're going to have to deal directly with the judge and not on the edges. On the next page, I talk about how there are really 3 major points that the Supreme Court has noted in one case about voluntarily dismissing. One, you need to file a motion. And that's the words they use, file a motion. And I say that because you can find some cases where the plaintiff orally moved for leave and nobody objected and the judge granted it. And I just want to point out that that could be a trap for the unwary if there was later the defendant wanted to make something out of that. Also, you have to give proper notice and you have to pay costs. Now, the Supreme Court has noted that the failure to give notice is relaxed, where the defendant has suffered no prejudice from the lack of notice, and also the requirement of costs is relaxed, where the plaintiff agrees to pay costs and the order requires plaintiff to pay costs upon presentation. What that means is this: you don't have to have your checkbook right there in court. You can put it in the order, and the plaintiff agrees to pay costs, and usually you don't even know the amount of costs. Usually the defendant comes up with that, in my experience, a few days later. The Supreme Court has also noted in another case that there are 2, quote, qualifications. One, where opposing party has previously filed a potentially dispositive motion. We're going to talk about that. That's now codified. in Section 1-009, and also when the dismissal would directly conflict with a specific Supreme Court rule. So let's go to page 5, and what are we talking about costs? We're talking about really minimal expenses. The Supreme Court uses Section 5-108 for the meaning of costs, and as you can see in these cases, it's used Black's Law Dictionary to define them. And they call it court costs, which such as filing fees, subpoena fees, and statutory witness fees to the losing party. But of course, that's meant to apply to a trial, the cost you get after a trial. When we're talking about pretrial costs, we're talking about much less, usually just the filing fees, service fees. Maybe you could get, I don't know, perhaps maybe you could get some subpoena fees that you had some witnesses or something like that, the defendant could. But basically, it's going to be pretty minimal. Then on page 6, look at the statute of limitations. It gives you, when you voluntarily dismiss without prejudice, you have a minimum of 1 year to refile. That means if the statute of limitations is already expired, you get a whole year to decide what to do and when to do it. If the statute of limitations has not expired, then you get whatever is greater, whatever time is left on the statute of limitations, or 1 year, whichever is greater. So it's a good thing for plaintiffs. Question then is, why would you ever want to file a motion for voluntary dismissal before trial? Well, clearly there can be all kinds of reasons. Maybe I'm just speculating. Maybe you're having some difficulties in prosecuting a case. Maybe your client is having some difficulties. It's possible those kind of issues could arise. But let's face it, what's more likely and what probably is going on most of the time is that the plaintiff wants to get away from the judge. It's now too late to file a Section 2101A2 motion to substitute as a matter of automatic right because the judge has ruled on some substantial issue. Or in some jurisdictions, the judge doesn't even have to rule on a substantial issue. All that has to be said is that you tested the waters, and that would be enough there. So the plaintiff says, uh-oh, I got to get out of here. And so the plaintiff may be worried that basically he's not comfortable with the judge deciding motions or trying the case. She may be worried about the outcome of a likely motion to dismiss or summary judgment. Maybe the judge has set unfavorable discovery or evidentiary orders and deadlines. And maybe, just maybe, the judge already has some rulings, barring some witnesses, or granting some motions in limine or something like that. So there's real cash on the table here. A trial date may be looming or nearing. Whatever, here you have a motion, a ready-made motion for voluntary dismissal. You don't need to say anything other than you want to voluntarily dismiss without prejudice, and as we'll talk about, you want to reserve with leave to refile, and we'll talk about the importance of the magical language. And you get at least 1 more year to do it. So what's not to like? Not so fast. The old Chinese proverb, beware what you dream for. I have a parade of horribles here. One is, if part of your case has already been dismissed on the merits, you have claim splitting when you refile the remainder of your case. And that means that it's going to be an issue of res judicata. And if the new judge finds that res judicata applies, your case is dismissed, your client is upset, and maybe even you get a malpractice action as a result. Another parade of horribles is if you've engaged in misconduct by avoiding, quote, compliance with discovery deadlines, orders, or applicable rules. Under Supreme Court Rule 219E, you risk having your client assessed with reasonable expenses, not attorney's fees, but a lot more than mere costs. Or if the new judge, in the refiled case, the new judge now is permitted to look at the orders and the discovery deadlines and everything that basically happened in the first case and that judge can then reimpose those orders and deadlines, or take cognizance of them, or calibrate for them. It's no longer a new board you start with. The Supreme Court has held that a refiled case is a new and distinct action. But that doesn't mean now that we have 219E that the judge can pull back out of that old ended dismissed case some of the orders and issues of discovery and the like that took place. And then, of course, if your opponent files a potentially dispositive motion per Section 2109B, that the judge has the discretion to hear that motion first. And if that happens, and the judge grants the defendant's motion, your case is lost, if it is in fact dispositive. If it's only partly dispositive, as it turns out, now you have claim splitting, because when you voluntarily dismiss and you go to refile the remainder, you have a dismissed part of your original action, and that means there's a claim splitting issue. Maybe talk about the parade of horribles. What could be worse than getting out of the case, having to go up to the judge and present your motion to voluntarily dismiss, and you know the judge senses you want to get out of his or her case. I mean, the judge isn't stupid. The judge may not care, or maybe will take a little bit of umbrage at it. Who knows? But now you see that same judge comes back in your new filed case. What's the point of having voluntarily dismissed if you get the same judge who knows what went on in the earlier case? Well, it can happen, and it has happened. On page 10, I note there's an unpublished case that where the first district in an unpublished case went out of its way to say the presiding judge obviously has the discretion to return the refiled case to the original judge. I don't know of any local rule that says that, but if you look at the next case, the Quintus case in the first district, somebody actually did that. It was called a request for an administrative transfer, and it was denied. But nevertheless, there was such a motion. It probably went to the presiding judge of law division or chancery division or whatever, and that was the judge who denied it. There's a second district case in Lake County, excuse me, that hinted that but for the original judge's retirement, the original judge would have gotten the refiled case. Didn't explain why that would occur. Let's go to page 11. There's actually two cases where the courts actually address the intersection of a voluntary dismissal and a right to substitute the judge as of right, because these poor plaintiffs pulled the same judge. They both, by the way, occurred in small counties. The Ramos case, I think, is Henry County, and the Bowman case is Jefferson County. But as we can see, it could occur in Cook County. The odds, I assume, are much greater that you won't get the same judge because there's so many more judges, but still, there's always the possibility of the unlucky draw. In the Ramos case, the judge denied in the refiled case, the same judge denied the motion to substitute. On appeal, the plaintiff argued that the refiled case was a new and distinct action, and the judge hadn't made any substantial rulings yet, so he was entitled to a substitution as a matter of right. The court agreed. The court agreed that this is a new and distinct action, but nevertheless, they went on. They affirmed the denial, going on the basis that you had had a chance to, quote, test the waters in the first case, and they used that doctrine to say, we don't think you can do it again. Even though the judge has not made a substantial ruling in the second case, you already knew all about this judge, and don't kid yourself. We know that that's why you wanted to get out. The next case, which was very recent, was decided, I think, on January 21 of this year, is the Bowman case. In that case, the court actually took Ramos one step further. They agreed with Ramos that testing the waters applies, but they also said, you know, alternatively, it seems to me, they said, not only will we deny the motion if you had a chance to test the waters, but we will deny the motion if the judge also had made a substantial ruling. Now, why'd they do that? They did that because there was a dissent. And the dissent brought to the fore the fact that the 4th District has disagreed with the doctrine of testing the waters. So the appellate court wanted to protect their flanks just in case it's reversed. And so obviously there had been a substantial ruling in the original case, and to make sure that they wouldn't be overturned for that reason. Now, it's interesting to me, I think the Supreme Court will make its next round of what PLAs it accepts, and you know it takes a very tiny percentage of them, in late May. And I wonder if a case is dismissed on January 21, that's the date you get the opinion, and you need 30 days to file your motion for PLA, and your opponent gets 2 weeks to respond. It very well could be that we could see this case accepted by the Supreme Court in late May, assuming there wasn't a motion for reconsideration, which can always take up more time, in which case you might see it in the next round. But this is the case that I could see the Supreme Court taking, because they have 2 issues here. They have the testing the waters issue, and they have the issue of whether you can be barred from getting rid of the judge you had in the original case, which, as everybody knows, but nobody will ever say, is a primary reason why the motion to voluntarily dismiss was filed in the first place. If I had to make a prediction, my prediction is they'll reverse. I don't think they'll undercut the statute. That's my prediction. It's that, and 39 cents won't buy you a cup of coffee. All right, now claim splitting. And this is the worry that a lot of people have, because it seems so hard to understand and so dangerous and risky, and it's really not. But you have to go through the elements to understand how to evaluate this. It all depends on res judicata. And res judicata has 3 prongs. The first is there has to be a final judgment on the merits. Secondly, there has to be an identity of cause of action. And third, the parties or their privies are identical in both actions. I'm on page 15, by the way. We will spend some time talking about the first one, a final judgment on the merits. That, to my mind, is the most likely issue that you will face as a plaintiff on refiling. The identity of cause of action is determined by the transactional test, whereby the courts look to see whether the facts that are alleged, the important facts, arise from a single group of operative facts, regardless of whether different theories of relief are asserted. And these, it seems to me that typically on a refiled case, typically or ordinarily, you're not going to deal with this. Usually, I mean, it's just one automobile accident with just certain plaintiffs. And it arose because the collision took place at a certain time, and there were certain injuries. And that's not going to change. So the most important issue may be, is there a final judgment on the merits? And here, you have to understand, I'm on page 17, the core concept of claim splitting, and it's this. The doctrine of res judicata bars not only what was actually decided in the first action, but whatever could have been decided. And that's the key concept. And so in Hudson, the court held that res judicata is applicable when the court finds that part of the case has been involuntarily dismissed on the merits, and the voluntarily dismissed claims, although not adjudicated on the merits, could have been decided in the original action. And that quote is more specific on page 18. So let's go on page 19 to the threshold issue. When is an involuntary dismissal a part of the action of final judgment on the merits? Well, actually, it's pretty easy. You looked at Supreme Court Rule 273. And Rule 273 says, when the order of dismissal or a statute, unless an order of dismissal or a statute otherwise specifies, or the dismissal is for lack of jurisdiction, improper venue, or failure to join an indispensable party, it's a judgment on the merits. It's a final judgment. So most dismissals, and we'll get to some language that can change that, are going to be on their face an issue of res judicata. But what this tells us right away is we better look at what the order says, because the order can be an exception. So let's go to page 20, and now we can have some examples that ought to bring this the issue and the concepts to light. The first case was the Hudson case. The Illinois Supreme Court decided it in 2008. There, the plaintiffs brought a count for negligence and a count for willful and wanton conduct. Nothing unusual about this. The court dismissed the negligent count with prejudice based on statutory immunity. Plaintiffs, well, the plaintiff said, boy, I don't like this. We got away, we lost one, and they probably said, this judge, we've tested the waters, and we don't want this judge deciding the next step, which is probably summary judgment. And so they voluntarily dismissed. They refiled the willful and wanton count. They haven't done anything wrong. They haven't refiled the negligence count, just the willful and wanton count. And the defendant raises res judicata. The plaintiffs conceded that the second and third prongs of res judicata, that is, the identity of transaction and the identity of parties, was not an issue. But what they said is res judicata could not apply. In other words, the first prong of final judgment on the merits was not applicable because the willful and wanton count had never been adjudicated. So it couldn't be res judicata. The judge never decided it. Held, all three of the res judicata elements applied to bar refiling of the willful and wanton claim. And the court said, element one, the final judgment, is met because the dismissal of the negligence count with prejudice operates as an adjudication on the merits. And although the willful and wanton count was not adjudicated on the merits, it arises out of the same operative facts as the negligence count, and so plaintiffs could have litigated it in the first action, and they decided not to. And so there you go. There's the paradigm case of claim splitting that results in res judicata. Now we also have, on page 21, the Piagenti versus Ford Motor case, which is a little bit different. In that case, the plaintiff brought count one for strict liability and count two for negligence. But both counts contained two really twin allegations of liability. I mean, both counts said that the vehicle was designed with insufficient stability, and second, lacked an adequate seatbelt system. So I suspect really, if they had done this right, there should have been 4 counts, not 2 counts. But they got away with it. The court granted partial summary judgment on the allegation of insufficient stability. Why? Because the plaintiff had not come up with an expert, and I guess the time to have an expert had elapsed, I assume, and so the court knocked it out. But it left the seatbelt allegations intact. But when the court granted the motion for summary judgment, it also granted leave to amend. Why? I don't know. I have no idea why the plaintiff would ask for leave. Had there some other things the plaintiff thought he or she should add, and that's why he did. But you didn't have to. You just now had what was left of the original complaint was still intact. You just strike the stuff about the instability. In any event, they decided we don't want this judge deciding the next step, which is probably another summary judgment or a trial, and so they moved to voluntarily dismiss, but after first filing an amended complaint. Hell, when the defendants raised res judicata on the refiled case, partial summary judgment was not a final order subject to res judicata because an order granting leave to amend indicates there has been no final disposition and cannot be a final order. So here you have language in the order. Remember what the court said about Rule 273. One of the exceptions to Rule 273 is a court order, what the order says. And here the court said leave to amend changed everything, even though, as I read this case, I mean, it really was an illusion. There was no reason for leave to amend unless the plaintiff added some new allegations that would not be subject to this, presumably, but I don't know. Then we go to page 23, and there's another permutation here that's worth noting. This is the Wilson case in the Illinois Supreme Court. Plaintiff brought an action against the hospital and doctors for medical malpractice. The plaintiff alleged in a single count that the doctors were either actual or apparent agents of the hospital. The court granted partial summary judgment on allegations that the doctors were actual agents, but not on the issue of whether they were apparent agents, because they found that to be a question of fact. Plaintiffs, of course, reading the tea leaves, voluntarily dismissed the case and refiled, and again alleged that the doctors were apparent agents. They did nothing wrong. They did not try to resuscitate actual agents. They just refiled what was left of their case after the partial summary judgment. Held, there was no res judicata, and this was by the Illinois Supreme Court, because the partial summary judgment was not a final judgment on the merits. The allegations of apparent agency and actual agency were not separate claims, but rather were separate theories of recovery. A single cause of action can give rise to several theories of recovery, and the plaintiffs have only one claim for negligence. So therefore, it was not a judgment on the merits, and there was no res judicata. So you want to always take a look to see what knocked out a theory of recovery rather than a cause of action. And usually I suspect this is going to be, usually if not always, when the court knocks out part of a count and not all of a count. And by the way, if you go back to the Ford case, you could see the Ford case could have decided this in the Wilson manner. I mean, the Ford case ended up saying leave to amend was dispositive. But what they could have said is the issues of the allegations of instability and seatbelts were simply theories of recovery and one cause of action for negligence. So that's interesting to know and keep in mind. Now on page 26, the Quintus Court says, what is an express reservation by the court mean? In other words, the issue is going to be, did the order expressly reserve your right to refile so that it's not a 273 adjudication when you dismiss and refile of whatever was dismissed. And they said, they cited Black's dictionary and said it clearly and unmistakably must communicate, directly state. On page 27, we have the Green case in the First District, and they said the words with leave to reinstate as a matter of right are magic words. Those words are the magic beans and Jack and the Beanstalk, and according to this court, if you use those words, you're going to be okay, according to the First District. Now, if we turn to page 28, this is interesting to me. I quoted there the footnote 2 to the Supreme Court decision in Hudson. And as I read this footnote, what it's saying is the words without prejudice will not be the magic words. They seem to be saying it's not good enough to say without prejudice. And if so, that's really scary, because most practitioners, I will bet dollars to donuts, the first words they think of, if they don't want to go looking up case law, is, all I have to do is dismiss without prejudice. That's what the statute says. Why do I have to do any more? So this could be a trap for the unwary. Okay, now on page 29. We had a second district case, and this is a good pedagogical tool, where the plaintiff filed a motion to voluntarily dismiss and said in the motion to voluntarily dismiss with leave to refile, or something like that. He or she had the magic words in the motion. The defendant objected.
I'm sorry to interrupt.
No, it's no problem.
You mentioned 3 different words: leave to reinstate, leave to amend, and leave to refile. Is there any substantive difference between them?
Oh, well, yeah, leave to amend would not be in the order to voluntarily dismiss.
Right.
So when you're talking about the order, you're going to be talking about some kind of words that indicate an express reservation of the right to refile. We're going to talk about that more. But that's what it's getting at. And you had the first district say, what, with leave to reinstate as of right or something like that, and they upheld that. They said, but you can have other words. But, you know, there's nothing like using words that a case is already pronounced, you know, their imprimatur on.
Right. So leave to reinstate or leave to refile.
Yeah, you want to get that across.
Okay.
Exactly. And so there was, the defendant objected in the written response, but did not object at the hearing in court. The court granted the motion and adopted the written order drafted by the plaintiff. But there was no mention in the order, like there was in the motion, of granting it with leave to refile. As a result, the court held on appeal that there was res judicata applied to the refiling because there was no magic words in the order. Now I think I can figure out what happened here, although it wasn't clear from the opinion. And it's understandable. All of us, I mean, this is, you know, there go I, but for the grace of God. The plaintiff felt, when I asked in my motion to voluntarily dismiss, I asked for a motion to dismiss with leave to reinstate. Judge goes, I'll grant your motion. The plaintiff writes down motion granted and figured that's the end of it, because it's implied, it's implicit in the motion that the plaintiff filed. But, you know, the court was a stickler, and that's what happened, so you can't do that. The court also said about the fact that the defendant did not object at the hearing. The court said that it doesn't, go ahead.
Well, I'm wondering what the point of that is. Is it to give other parties notice that this case could be refiled within a year, that it's absolutely clear based on the record if someone would look it up that you can refile?
I don't know if it's that that clear. It seems to me what it is the Supreme Court has adopted the restatement of judgments, which gives 6 scenarios, exceptions, where claim filing can stand against res judicata. One of them is when the order expressly reserves the right to refile. And remember too, Rule 273, the Supreme Court said, one exception to it is an order that says language that would make it not a Rule 273 adjudication. So I don't know if they're thinking of notice. I think what they're thinking of, this is what you have to do. These are, you know, the magic beans, the incantation. I think what it is, deep down inside, I think what happened is in the mid-90s, the Illinois Supreme Court got the Rhine case. And they looked at it, and maybe they said, you know something, we got to start cutting down motions to voluntarily dismiss. Until in fact, the late 80s, this was the Wild West. Motions to voluntarily dismiss was, I mean, it was pretty much anything you wanted to do. You want to get rid of the judge the day before trial, you have a right to do it as long as the trial hasn't begun. I mean, it was the Wild West. And finally, the court began to make inroads, and here, this was presented to them. It works theoretically and conceptually. It works. And they said, okay. But nobody, I have the feeling that it wasn't until the Hudson case, about 15 years later, in 2008, that practitioners really got the word. Until that time, the Ryan case, I think, was sort of seen as sort of an oddity. Who can believe that? I have a right to voluntarily dismiss, but the Hudson case made it clear. And if I remember, there were some dissents in the Hudson case. I know it wasn't just the Ryan case, but the Hudson case. There were some justices who said, this isn't right, this isn't fair, it's a trap for the unwary. But we were talking about the Nye case, and what the other thing that the court said is, you don't have to object, the defendant, at the time of the motion to voluntarily dismiss, to the refiling. That's something for you to object to when there's a refiling. So the fact that the defendant didn't object didn't mean anything. Now, here's an interesting issue. Let's assume you file a motion, and the motion says, I ask the court to voluntarily dismiss the case with leave to reinstate. And the judge says, counsel, I will grant your motion, but I won't allow you leave to reinstate. I'm just not going to do it, because this judge doesn't want to see a refiling. This judge knows this plaintiff wants to, there's some history probably for the judge to want to do that. So what do? Well, if I was a plaintiff, I'd say, well then, judge, I guess our case remains before you, because you haven't granted my motion, so I asked for leave to reinstate, so you can't say that the case is dismissed. You can't do that. Now, if a plaintiff was so unwise as to file a motion that didn't say with leave to reinstate, and the judge says granted, and the plaintiff says, oh, by the way, judge, I want leave to reinstate in the order. That may be too late if the judge wants to be a stickler. Now, here's something, pay attention, you Circuit Court of Cook County practitioners. Here is some manna from heaven that may still exist, as far as I know. But I don't know. But it existed until recently. There are 3 First District cases which hold that when the order is silent about leave to reinstate, but the computer docket entry says leave to reinstate, you're okay. You can refile. The Sam's case, which was unpublished, explained how this happened. And what it is simply about the way the computer system works. You have an entry for denial of the motion to voluntarily dismiss, and then you have one for granting of the motion to voluntarily dismiss, and it automatically, with the code, it says with leave to reinstate. And in fact, one clerk testified that she assumed anybody who filed a motion to voluntarily dismiss wanted reinstatement. So I have no idea in these cases whether there was any colloquy with the judge. Obviously, the order that was written by the plaintiff did not give the magic words, but they were saved. Now, I don't know whether that's been corrected or not. Let's go to page 33.
So what happens if the opposite occurs and they don't press the right code, even though you have it safe, right?
That's right. If the order says with leave to, yeah, you're safe. You don't have to worry. I mean, the order.
They miscode lots of things.
Yeah, that's true. Yeah, good point. But the order will always trump the docket entry. So that's the good news, always. And that's why, I mean, this worked because the order was silent. It didn't contradict the docket. Had it contradicted the docket entry would be null and void. There is also on 33, I talk about acquiescence. There's not much to say about this. I mean, clearly, if you're a defendant on a refiled case, assert res judicata, at least as an affirmative defense. If not, I wouldn't know why you wouldn't raise it as a motion right off the bat, but there were two cases where for some reason people didn't see it, I guess. They waited 3.5 years, it was too late. All right, so much for claim splitting. Now let's go to Rule 219E on page 35 that talks about notwithstanding an order to voluntarily dismiss without prejudice, a party shall not be permitted to avoid compliance with discovery deadlines, orders, or applicable rules. It directs the court in refiled cases to consider prior discovery deadlines and orders, and it also permits the court in the original case to award reasonable expenses for avoiding compliance with discovery deadlines, orders, and rules. So there's two prongs to that. There's a monetary burden that can happen, and there is, you may get a new judge, and maybe that's good for you, but you're going to get, the new judge is going to be able to look at all the things that were done, and if the new judge thinks you were evading something, or something, you're trying to get a second crack at the apple with discovery orders and things like that, you're likely to be in deep trouble. The judge is not required to reimpose those orders, but as a practical matter, unless it's Mother Teresa who's suing, expect real problems with the judge seeing what you're doing. Let's go to the reasonable expenses that are on page 40. Now, reasonable expenses still does not include attorney's fees, but it includes a lot more than mere costs. It includes discovery expenses, expert witness fees, reproduction costs, travel expenses, postage, and phone charges. Well, think about it. I mean, expert witness fees, those can be very substantial. Discovery expenses, sure. Transcripts. I have a feeling that if you take a deposition out of town, your room and board is going to be included in that too. So there's some serious money here. Yeah.
We had a few cases a few years ago we have a foreclosure mediation program, and we alleged that the plaintiff was abusing the process and not mediating in good faith without motions for sanctions. And in a few cases,
Not mediating,
not mediating in good faith,
like arbitration, you have to, yeah.
and claimed that was a basis for sanctions. And the response for a few cases was an immediate motion to voluntarily dismiss.
Yeah.
And we tried to claim that the 219E isn't just for discovery, but any kind of pretrial orders, which include mediation and things like that, and that he should decide our motion to sanction before allowing them to dismiss the case to see if there were any reasonable expenses in mediation that were to be paid. And the court, in a few cases across the board, said, no, I'm not going to keep them hostage in this case, and I'll dismiss it. If you want to raise that in the next case as a counterclaim, you can. Or refile the motion if it goes back to mediation. So do you think that's the appropriate result, or do you think that 219?
I think that's, I think that you can find case law that you can make a very good argument with the judge. That's included. I think you can. And, clearly, there's the old saying that goes for everything in litigation. You take the law and I'll take the facts and I'll beat you every time.
Right.
If the judge perceives that this party is fooling around and, there's going to be a price to be paid if the judge knows what authority he or she has. Now, that's the issue, whether you can get that. Now, maybe the judge just wants to say, listen, give the plaintiff their right, let them get out, all that. And maybe that's the case, but I think it's a very good argument. I think that, had it been worth it, you might have appealed it. You might have gotten a reversal out of it. Keep in mind that the award here is against the plaintiff. The words is require the party voluntarily dismissing. It does not say attorneys. So the award is not against the attorney. That may be a little bit of relief for a plaintiff's attorney, but doesn't do much good for the poor plaintiff. Now, if you go to 41, what you should also note is that Rule 219C talks about sanctions for discovery violations in the ongoing case. And it's important to note this because several of the cases on 219E look to 219C to find out what their standards should be. Really, there's a knee-jerk reaction not to distinguish E from C, even though the language is very, very different. And you see that in fact, in the, I think the case, the scattered case we'll get to, actually, it's on page 43. This was, I think, the first, or at least one of the first cases to deal with 219E. And they generously helped themselves to 219C cases because they had nowhere else to go. So they figured, well, rather than try and make it up, let's look at 219C and sort of grab some analogies. And what they held is that they believed, they looked at the committee's the committee notes, which are also important to look at, and they say the committee was emphasizing non-compliance, and that indicates that voluntary dismissal must involve some disobedience on the plaintiff's part. And they noted the language of 219E to avoiding compliance with discovery deadlines, orders, or applicable rules, and they think that it required a preliminary finding of misconduct analogous to the unreasonable non-compliance standard that's in 219C. So they really helped themselves to 219C to come up with a standard. And where they came up ultimately was there is 219E award when there is deliberate, contumacious, or unwarranted disregard for the court's authority. It doesn't, and they made clear 219E doesn't stop you from voluntarily dismissing, but it surely is going to be an impediment if you're using it as what they call a dilatory tactic. Now, they say the court must make a preliminary finding of misconduct. I don't know what that means. Does it mean specifying what was wrong here, like you do in Rule 137 and 219C, a written order that has to specifically say what the plaintiff did wrong? They don't say, and we'll talk about that in a minute. The Supreme Court, although 219C uses the word sanctions, 219E doesn't. So the Supreme Court bridged the gap and says, well, 219E, reasonable expense award, is in the nature of sanctions. 219E, we have some examples of when expenses were awarded and how much on page 46. Look at the first case, the first district in 2002. The court found that plaintiffs had sought voluntary dismissal in order to avoid the effects of pretrial evidentiary rulings based on their own failure to comply with discovery deadlines, many of which barred the plaintiffs from presenting certain witnesses or evidence due to untimely disclosure. And the amount was nothing to sneeze at, $80,000. So what this tells us right off the bat is, if you're at the point where you've already been barred in some way with discovery or an evidentiary ruling, a motion in limine, you're going to be in trouble for sure if you now try and get out of the case. I mean, that's just the fact. You still can, and you may avoid 219E, but you're going to have an issue. No defendant would miss this. Then we go to the Jones case, which awarded reasonable expenses, even though the court did not find that plaintiffs deliberately violated or failed to comply with any orders or deadlines, and did not find that the plaintiff's reasons for dismissal were pretextual. The court still found that plaintiffs had used their right to voluntarily dismiss to avoid the consequences of the court's ruling on the motions in limine to avoid the barring of plaintiff's witnesses and evidence occasioned by plaintiff's failure to disclose pursuant to Rule 213F, which of course are interrogatory answers. And they awarded $181,000. No slouch here. So there's another example of trying to do it late in the game. In the Yehu case on the next page, the court barred plaintiff from amending the complaint to add Dr. Darby due to expiration of statute of limitations. The plaintiff subsequently took a voluntary dismissal and refiled an action against Darby, and the court found this was an attempt to circumvent the prior court order. This case is decided wrong. No wonder it's unpublished. The second court has no right to impose Rule 219E award. That has to be done by the first case. That doesn't mean the plaintiff shouldn't be sanctioned. I mean, once that order, presumably in the original case, was on the merits, the one against Dr. Darby on the statute of limitations. So there was no basis for them to refile against Dr. Darby. This should have been Rule 137, not Rule 219E. And look at the amount that was awarded, $2,100. I mean, it's pennies. So it's an odd case. Next case, the Bettis case, also unpublished. The plaintiff, nearly 4 years after the case was filed and 2 months before trial, the defendant filed a motion in limine to bar plaintiff's experts and for a Fry hearing. 1 week later, the plaintiff filed a motion to voluntarily dismiss. They got scared. They said, uh-oh, what's this? Motion in limine, Fry hearing? I could lose my whole case. So they tried to get out. And the court assessed them for $4,700, which again is paltry. This was a case that went on for 4 years. I mean, there's very little there that, to my mind, in a case that goes on for 4 years, and they probably didn't do much discovery. And then finally, the Wagner case. This is interesting. The plaintiff failed to answer supplemental interrogatories, and the court ordered plaintiff to answer. The court found the interrogatory answers were disingenuous and ordered plaintiff to further respond. The plaintiff's response the next day was to file a motion for voluntary dismissal. Well, clearly, I mean, it didn't take much for the court to see what was going on here, and the court obviously didn't like it. This is a published decision, but they never published the amount that was assessed. The 219E reasonable expenses are in the court's discretion. And you can only reverse that if you can show that no reasonable person would have held like the trial judge. Now think about that. No reasonable person. In order to reverse an award, you basically have to show that this judge is irrational. It's irrational. No reasonable person, would ever think of doing this thing. And by the way, it's the same thing for Rule 137 sanctions. It's the same thing for Rule 219C. So there's nothing unusual about this. But I bring it up because I always found this bizarre. Now think of it this way. The judge assesses $100,000 against your client on 219E, or against you, the attorney, on 137, and you can only reverse it by showing the judge is irrational. Compare that to, you try the case, the judge awards $100,000 to the plaintiff, and you're the defendant. What is the issue? Manifest weight against the manifest weight of the evidence. And all there you show is that the opposite conclusion is clearly evident, or the determination is unreasonable, arbitrary, or not based on the evidence presented. Now that's still a difficult standard. It's nothing to sneeze at, but it's nowhere near saying the judge is irrational. But that's the law. And and as far as I know, nobody's ever raised it and probably wouldn't get anywhere if they did. Let's go to 51, page 51. This is an unpublished case, but it makes a good point, and it's interesting. It may, this gentleman was talking about a foreclosure action. Here the plaintiff bank brought a foreclosure action. The defendants noticed up the deposition of a reputed robo-signer. That's a guy who signs affidavits in a wholesale manner in a foreclosure case without possessing the requisite level of personal knowledge. Obviously, the defendants were going for the jugular. The next day, the plaintiff bank orally moved to voluntarily dismiss, and it was granted. The defendant sought Rule 219 award on the basis that plaintiff's motion was a ruse to evade discovery. Well, the court, the first district said, no, we're not going to award 219E, while the plaintiff's voluntary dismissal necessarily prevented Selman from being deposed. We find nothing in the sequence of events that evidence plaintiff's noncompliance with any discovery deadline, order, or applicable rule. So the point is, and I wish this case had been published, the point is, well, of course when you move to voluntarily dismiss, of course you're precluding discovery. But that really, I mean, that's what voluntary dismissals are all about. And so it makes sense, even if it was an evasion, it makes sense that the court's decision. Same idea on the next page, 52. Merely because a plaintiff's intent is to obtain a different judge should not in and of itself lead to a 219 award. Well, clearly it's the same thing. You know, everybody understands that one of the main reasons you're going to voluntarily dismiss is because you want a different judge. And so if you said that this was an evasion, then you could never get out of it without 219E award. Same thing on page 54, where the court said, two courts, one court held that, the scattered court held that, of course, you're evading trial. When you have a trial date set, a voluntary dismissal necessarily avoids a trial. But the court must find unreasonable noncompliance. So that left some room. Maybe if you try and voluntarily dismiss 2 days before trial, maybe that's going to bring a different result. There's some wiggle room here. But generally speaking, in and of itself, it shouldn't be a reason for an award. But here you have the Ramos case, third district case. The fact that the trial court found that the voluntary dismissal was taken to avoid going to trial, the date of which had been set by the court, was insufficient to impose Rule 219 sanctions where no finding of misconduct or unreasonable noncompliance with court order took place. So again, there's wiggle room here, but there should be something more egregious. We've already talked about on 55 that a 219E award must be levied in the original action, but note the Jones case, the case that awarded $182,000. In that case, the judge conditioned the payment of the $182,000 on refiling of the voluntarily dismissed action. So the judge gave the plaintiff a break. The judge said, you're not going to have to pay this unless you refile. And I will bet dollars to donuts that case was never refiled. The next page, 56 and 57, we have this issue of why Rule 219C and 137 requires a specific written opinion saying what the misconduct is. You can't get away with let the record show. But 219E doesn't say that. And keep in mind, this isn't the case of a of a legislature that simply overlooked it. Remember, 219 is drafted by the Illinois Supreme Court, so somebody apparently wanted to make a distinction there. All right, and lastly, let's go to 59. And lastly, there is, as I said, in 1989, the Illinois Supreme Court, for the first time that I'm aware of, cut back on voluntary dismissal, which, as far as I'm concerned, until that time, had been the Wild West. It was done, at any time, for any reason. It was a birthright of a plaintiff's lawyer. And now they held the court may hear and decide a motion which has been filed prior to a Section 2-109 motion, when that motion, if favorably ruled upon by the court, could result in a final disposition of the case. And then it followed that up in 1990 with the Fumarolo case, where they said, it doesn't always have to be that the defendant files the motion first. I mean, and that's clearly evident. That's unfair if they file it first and the plaintiff then tries to file the motion to dismiss and gets that heard first. But they said if the defendant has sort of indicated that he or she is going to file it, in that case, we'll say that's the same thing as filing prior to that time. In this case, the defendant had apparently talked about it. It was coming. I get the feeling, just a feeling, it was imminent, and the court wasn't going to let the plaintiff rely on a technicality. I also note on page 62 the issue of an oral motion to voluntarily dismiss. Yeah.
There's a question for a motion to sanctions that comes after a motion to voluntarily dismiss. How would that? You only hear a dispositive motion before the motion to
Why would the motion to dismiss be contemptuous?
If the motion to dismiss is to evade discovery deadlines, how would you file that motion? When would you file the motion?
You would file that. Remember, it's got to be filed in the original case. In the best of all worlds, you would file that, or you would tell the judge that at the time, in the best of all worlds. But I don't think you have to worry. Remember, the judge keeps jurisdiction for 30 days. You can wait to file your motion for sanctions, 137 sanctions as well. So you know something? The defendant might arguably say, I don't want to alert the plaintiff to this. Let the plaintiff get what the plaintiff wants, and 3 days after the motion is granted, I'll file my Rule 219E. So that's what I think is a serious possibility. One more thing about the historical perspective. There was one, I can remember, there was one issue that limited the Wild West, and that is the statutes up until 1994, the 2-1009 statute, provided that you could not voluntarily dismiss when the defendant already had a counterclaim on file. That barred you. And interestingly, that was eliminated in 1994, and then in 1996, the Supreme Court added 219E, and clearly what was going on is it had come to their attention that plaintiffs were getting away with just too much on voluntary dismissals. Okay?
I have a question, going back a bit. In cases where the plaintiffs came back in and tried to refile the case and then tried to substitute a judge, but there had been a substantive ruling. What if
there's a substantive ruling in the original case?
In the original case, and they end up with the same judge,
right.
And they try to substitute judge in that situation. What would happen, do you think, if a defendant tried to substitute that judge? Under the rationale of the courts, there have been substantive rulings. Maybe the defendant can't get out.
Yes, very good point. The rationale applies to the defendant just like the plaintiff. Same thing. You tested the waters. I think that's a very good point. I never thought of that, but you're right. It also could hurt defendants. who get somebody, you're right. But I think,
I mean,
You know, I-
an unusual set of circumstances, the
yeah.
defendant would feel like they were getting a bad judge.
You see, the
But-
reasoning in those two cases are that the plaintiff is the one who should be castigated, because they were the ones who did this slippery thing of a voluntary dismissal. The defendant didn't do that. So I could see how, if you look at the equities are much more with the defendant. It isn't the defendant's fault, you know, and the defendant is not has an automatic right to strike. But I'll tell you something, that would be to the plaintiff's lawyer on appeal of the Bowman case. That would be a very good argument to make, you know, to the court. You know, look at, you're not only getting the plaintiffs who did this, you're going to castigate the defendants too. You're going to undermine their automatic right to substitute a judge. So it's a very good point you make.
If you dismiss with leave to refile and your statute of limitations says run, but you have that additional year, is there any difference if you file the same lawsuit as a new case, or do you have to reinstate it as the previous case in order to?
No, you don't have to. I mean, to the extent that your claim was part of the action, this is the way I would analyze it. To the extent that the claim that was barred by the statute of limitations was part of your original case and never adjudicated, I would think the statute of limitations is automatically going to be extended for the new filing insofar as that issue is concerned. If you add in the second filing issue B, which never was raised in the original filing, no, that's not going to. Any other questions?
Online.
Okay, I think I'm done.
Thank you.